Hi, Tim Blankenship here with Divorce661.com, and in this video I want to talk about some bad advice that someone I just got off the phone with got regarding procedural steps in their divorce. So let me set up the scenario for you. And this, a lot of this has to do with people doing their own divorce. This is the biggest cause. It can happen to anyone, but if you're doing your own divorce, this can certainly happen, and it is very problematic. So what happened is the client's spouse filed for divorce, served her, filed the request to enter default, and then moved out of country, never to be heard from again. Now, her, as the respondent, has basically less options at this point because he's no longer available. I guess there is some communication, but they are not willing to sign any paperwork moving forward. And he kind of holds all the cards as the petitioner. And the bad advice that she had received is they told her to cancel the divorce because he's the petitioner, and to refile a new petition and then try and serve him wherever he may be. She knows he moved out of the country but doesn't know exactly where. I told her this is probably the worst advice she would have received, because to file a new case, now you can't even start the clock on the 6 months until that person is served. And if they are out of country, there are all kinds of international laws that apply to make service of process very difficult, especially if you don't know where they are. So what I recommended in this case, I looked up her file, and the request to enter default that the petitioner had filed had actually been rejected. So what I recommended is that we file the response, enter into the case officially, file a trial setting request to get a hearing with the judge so she can explain to the judge what's going on, so the judge can set a path to finalize the divorce without him. Because as the petitioner, you need to, even if it's a contested case and you go to trial, both parties need to sign off on the judgment. So what has to happen in this case is the judge has to make an order that he's no longer available. The court will probably send out 1 or 2 notices to the last address on file to let them know that there's a trial date. There will be a trial date. The court will then divide the property, and then the divorce can finalize as a judgment by the court as opposed to an uncontested case or a case by trial. So if you are the respondent and you find yourself in this predicament and you haven't filed a response and you haven't been defaulted, go ahead and file a response. It's the only way you can officially enter the case, and then you can take some actions such as requesting a trial setting conference so you can move your case forward.